this point in the agenda, we have a presentation on the REINS Act. REINS stands for Regulations from the Executive in Need of Scrutiny Act. We have Becki Gray, Vice President for Outreach of the John Locke Foundation, and Jon Sanders, Director of Regulatory Studies at John Locke Foundation. Thank y'all for being here. We have a copy of the report in your materials. It's the one with the bucking bronco. They're going to rein in government. When I first heard REINS, Becki, I thought of like a Wells Fargo stagecoach trying to slow down. So,
that's exactly what it means.
please present us. Thank you.
Thank you so much. Good morning, Chairman George, and members of the committee, staff, and others interested in today's topics. My name is Becki Gray. Thank you. My name is Becki Gray, Vice President for Outreach at the John Locke Foundation, and thank you for the invitation to speak with you today. I'm going to speak briefly about regulations in North Carolina, and then my colleague, Jon Sanders, is going to provide an in-depth look at the rationale and features of a REINS Act, R-E-I-N-S, a REINS Act in North Carolina. And you're exactly right. This would rein in the rules and regulations and the burden that this places on North Carolinians. But to start off, I want to give you two numbers to keep in mind. And if you would, write these down, because I want you to keep this in mind as we're talking about this issue. The first number is 21,751. 21,751. And the second number is 3.1 billion. As of March 2014, North Carolina has 21,751 rules in the administrative code. 21,000 rules in the administrative code. 5,551 of those are in Health and Human Services. 3,253 are with occupational licensing boards, and 2,980 are in Environment and Natural Resources. Now to the 3.1 billion number. The Beacon Hill Institute estimates that in 2015, North Carolina's regulations cost our economy a minimum of $3.1 billion. And when everything is factored in and things that economists figure in when they're figuring this number, that cost could be as much as $25.5 billion. Now keep that number in mind. That number is larger than our entire general fund this year in cost that these regulations have to our economy. And if you think about it this way, every rule has a cost associated with it. And you multiply that cost by 21,750 and then multiply that again by every person, business, or industry that has to comply with that rule, and you see the impact that these rules have on our economy. When we're required to get a safety and emissions inspection on our car every year, that costs each of us $30. When an entrepreneur is required to install a sprinkler system in their facility, there's an additional cost of up to $7 per square foot just to start that business. The cost may be an opportunity cost. If you think about the business owner who has to spend hours going through red tape, comparing federal law with state law, with local ordinances, to ensure that he is complying, that time could have been spent instead investing that time and energy and resources into building and growing his business and creating jobs in North Carolina. Now, there's a cost to the taxpayer as well. As government grows bigger and bigger, hiring more staff to police and enforce more and more rules, the cost goes up. A bigger government costs more as the layers of bureaucracy grow, and those charged with enforcing the rules settle into jobs that become departments that then grow into agencies. And when more resources go to enforcing rules, there's less money available to pay for our good teachers, to pay our law enforcement officers, and those other core functions of government. But the biggest cost that we pay is our loss of freedom. Whether it's what kind of flowers you can plant along the creek bed in your backyard, or time-sucking compliance with duplication of federal, state, and local rules, or restrictions on where you can park your food truck. Every rule has a cost to those who have to comply with it, and often that cost is our freedom, the freedom to enjoy the fruits of our labor and to pursue our dreams. Now, often these costs are the result of outdated, unnecessary, duplicative, overly burdensome rules, and low-income families and struggling small businesses are hit the hardest as these rules grow and expand. Now, I'm not suggesting in any way that we should have no rules. We need rules for order, consistency, and fairness to protect public health, to protect public safety, and to protect the environment. But what's happened over the years is that the authority has gone from you, the legislature, to unelected government bureaucrats with no oversight and no accountability. As far back as 1978, the North Carolina Supreme Court warned that the delegation of legislative rulemaking power should be closely monitored. And here we are all those years later. Now, under our state constitution, and I carry a copy with me everywhere, and I hope you do too, under our state constitution, the General Assembly has the authority and the duty to enact laws. And you all do a great job with that. You study, you debate, you discuss, you take public comments, your bills go through numerous committees, they go through votes, you offer amendments, they go through scrutiny, there's analysis. All of that happens before those introduced bills become law. But let me give you an idea about what happens with the rules. So from 2003 to 2010, 19% of the bills introduced in the General Assembly became law. But from 2004 to 2009, 99.9% of the rules made by unelected government bureaucrats went into effect. Now, you all have started to address the overregulation and the rules burden. Senator Jackson and I were talking about this before the meeting started. You started with the Regulatory Reform Act of 2011, and you followed that up with a Regulatory Reform Act every single year since then. You now require a regular review of laws, a cost-benefit analysis. You disallow state environmental laws from being more stringent than federal laws, and you offer guiding principles for new rules. But there's still more that you can do. We propose a tool to return rulemaking authority to the General Assembly and increase accountability and transparency. Under a REINS Act, major rules would require a vote from you, the General Assembly, and with the governor's signature. And without your approval, that proposed rule would die. Major rules are those with significant economic impact. Now, this is an idea that's passed the U.S. House of Representatives 3 times since 2011. Policymakers and thought leaders in other states are looking at adopting a state-level REINS Act. As a matter of fact, we've had calls from people in Mississippi, Florida, Ohio, and Utah just this week with looking for guidance on how they could implement a state-level REINS Act. You all have made North Carolina a national model in tax reform, in education reform, in the restraint of government growth. Under your leadership, North Carolina can become a model in rules and regulation reform as well. The John Locke Foundation recommends the adoption of a state-level REINS Act, and I hope you'll take a close look at this. And my colleague, Jon Sanders, who's the Director of Regulatory Studies, has written extensively on the REINS Act, and he's going to fill you in on all the details associated with this. Thank you.
Thank you, Ms. Gray. Welcome, Mr. Sanders. Welcome back.
Thank you, Mr. Chairman. Thank you, everyone, for being here. Give me a second and see if I can do this properly. Okay, a good start. I am Jon Sanders. I'm the Director of Regulatory Studies at the John Locke Foundation, and I'm here to present on what I call the rationale and features of a REINS Act in North Carolina. I want to open this with some nods to the economic research literature on the problem of red tape and overregulation. These first quotations are from some local economists, John Dawson of Appalachian State and John Cedar from North Carolina State. They did a landmark study very recently on the impact of federal regulations over time. Now, it's federal, not state, but I would argue that the same process takes place in the state as well. All of the studies that they looked at, almost all the studies concluded that regulation has deleterious effects on economic activity, which makes sense to me as an economist. If you make an activity more costly, either in terms of time or in terms of financial cost, there's going to be less of it. So if you make an economic activity more costly through putting up hurdles, through regulatory burdens, through compliance, there's going to be less of it. You have my presentation. I'm not going to belabor the point too much, but the least regulated industries over time have proven to grow faster, and the more regulated industries are growing slower. So this is not just on a macro level, but also on the micro level as well. These effects are not only annual, but they have cumulative long-term effects. Dawson and Cedar found that for the United States economy, GDP is now about 1/4 the size it potentially could be, owing to growth in the regulatory burden. This chart here is based on their numbers. That first one is the GDP in 2011 if regulation at the federal level had remained at 1949 levels, $53.9 trillion. The actual GDP in 2011 was $15.1 trillion. So basically, the opportunity cost of federal regulation growth from 1949 has been almost $39 trillion. I would argue that that same process is taking place in North Carolina. Red tape is producing a cumulative drag on the economy. And in the federal government, as Clyde Wayne Cruz, who does an annual review of federal regulation, executive agency officials were passing a new rule, 16 new rules for every new law dutifully enacted by Congress. As my colleague Becki Gray put forth, that this gets to the actual system of government. As we remember from our civics classes, and as you work with every day, we have a threefold branch of government here. The legislative branch actually passes the laws, enacts the laws. The executive branch executes the laws and carries out the laws, and the judicial branch interprets and upholds the laws. But who makes the rules? Rules are made by executive agencies through delegated power from the legislature. Rules carry the full force of law, but they are not made by legislators who are directly accountable to voters to pass the laws. Their authority is delegated. This works, and it makes sense when the legislature has passed an overarching law and they need subject matter experts at the agencies to help them implement. There's a risk, however, a great risk of state law being crafted without input by those vested by the voters with lawmaking authority, especially the greater the economic impact of the regulation can be. So the more economic impact, the greater the risk of state law being crafted without consent of the governed. Becki mentioned these stats. This is a chart that I put together in my study that is, I believe that y'all have. This is the growth in red tape, bills becoming law versus rules going to effect in North Carolina during a comparable time period. As you can see, there were way more proposed bills in this time period, almost 3 times as many bills. But only about 19% of bills actually progress into law, owing to the deliberative legislative process, and this is a part of that process. Rules, once they're proposed, almost all the time end up taking effect. 99.9% of the time during that study period. So it seems as if rule growth, red tape growth, is a fait accompli once it's been proposed. My numbers here, I've got roughly 25,000, and that's taken from a recent study from Beacon Hill, roughly 25,000 individual regulations. Becki has updated numbers, it's 21 something. Of those, over 10,000 of those rules impose burdens on the private sector. Some of them, of course, affect other aspects of government like the UNC system, community colleges, and that sort of thing. But over 10,000 rules impose burdens on the private sector through fees, through budgetary appropriations, through compliance costs and the like. So as Becki mentioned, the starting point of the estimated cost burden annually on North Carolina of those rules is $3.1 billion, but they could add as much as $25.5 billion. The reason for that disparity in cost, why there's such a large gap, 3.1 to 25.5, is that the economists for Beacon Hill were unable to establish cost impacts for most of those titles. And they were unable to calculate opportunity costs to the private economy of resources that are going into compliance costs. So if it's going into compliance as opposed to a productive activity, they weren't really able to calculate what the actual opportunity cost burden of that. Their view was that 3.1 billion is but a fraction of the total cost because the number of regulations for which they were unable to estimate costs outnumbered by far the number of regulations for which they were. But as I mentioned earlier, the legislative process is more deliberate. There's subcommittee meetings, there's votes, you take a bill, you look it over, you make some changes to it. You have concerns about constituencies, you have concerns about this side of the state, that side of the state. So the process in a bill becoming law requires a lot of looking. It's much, much more deliberate. That same process, however, makes it difficult for the General Assembly to block a proposed new regulation. I mean, there is a system in place for that to take place, but it's very difficult. So the unintended consequence of this deliberation when it concerns major rules, the rules that have deep impacts on the economy in the state, is that it undercuts lawmaking being the role of elected legislators. There have been several recent regulatory reforms for which the General Assembly in this session and previous sessions has to be commended. Many very good reforms. I've listed several that I think were especially good. The one I would especially highlight here, and I see will be spoken of even more after this, is sunset provision with periodic review. I think that was a very important and key reform, and it enables us to now speak about things such as REINS. The reason I say that, a recent review by Mercatus of regulatory processes used in the 50 states found that the presence of a sunset provision with periodic review to be robustly statistically significant in reducing a state's overall total level of regulations. Most of the other processes they did not find to be much use at all. Their finding for periodic review and sunset was robustly statistically significant, but also economically significant. So their conclusion was that for effective regulatory reform, the single most important policy in a state is the presence of a sunset provision. That being said, the sun also rises, as Hemingway would put it. Now, with the sunset provision and periodic review in place, policymakers can focus on proposed new regulations instead of the established ones. Sunrise provisions, laws that are affecting proposed new regulations prior to their adoption. They would be a complement to sunset laws, especially as the review process takes into account how new regulations are made. And in my opinion, chief among these is a state REINS Act. REINS Act, as mentioned, is legislation that has passed the House in 3 consecutive sessions. It's currently before the U.S. Senate now. The acronym for regulations from the executive in need of scrutiny. It's quite a tortured acronym, I'll give you that, but I think it makes sense. What it does is it would require Congress to pass a joint resolution to approve any proposed rule that would have a major impact on the economy. Not just any impact, a major impact. The rule would not be allowed to take effect without this joint resolution. The resolution must pass within 60 session days of report of the rule, and Congress also importantly, is not obligated to do anything. So they're not obligated to draft this resolution. The regulation would have to be compelling enough on its own merits for the Congress to want to do this. The goal, more transparency in the process, better considered laws and rules, and more accountability. I put the statutory purpose. I'm not going to read all of this because I know your time is valuable. It's in my presentation, but this is within the REINS Act of 2015 where I got this purpose from. It applies only to proposed major rules, which in federal legislation is something that would have an annual effect on the economy of $100 million or more. Major increase in cost or price for consumers, individual industries, government agencies, geographic regions, or significant adverse effects on competition, employment, investment, et cetera, et cetera. So the impact, the focus is on major rules. It's not on all rules because that would bog Congress down more so than they are. One of the major issues with REINS, of course, would be, is it constitutional? The idea appeared to have generated from comments before Georgetown University Law Center delivered in October 1983 by Stephen Breyer. At that time was a federal appellate judge. This is prior to his being appointed to the Supreme Court by President Clinton. There is strong support for it in the economic literature, in the academic literature, for its constitutionality. It is not 100% support, but the strong, solid majority that I've seen has been in favor of it. In my paper, I mentioned a couple of papers that are not in favor of the constitutionality, so I list several on either side. For North Carolina, features of a REINS Act as I see it, the first one would stipulate that only proposed new rules projected to have substantial economic impact would fall under REINS scrutiny. North Carolina already has, thanks to some of the recent regulatory reforms, a statutory distinction for major rules. That is the term substantial economic impact. In the general statutes, it means an aggregate financial impact on all persons affected of at least $1 million in a 12-month period. So it will stipulate only rules that have substantial economic impact would fall under REINS. It would allow, but it would not require, a General Assembly to consider a joint resolution to approve the rule. And it would mandate that without that affirming joint resolution, within a set period of time, say 60 days as it is in the federal legislation, if it's not passed within that time period, then that proposed rule would expire. Two other things I think would be important to put in there is, one would be to clarify that a vote approving the joint resolution in the General Assembly is not the same as a vote to enact it as a law. It's just a vote to allow it to proceed along the rulemaking process. And then 5, to retain the existing procedure within the General Assembly to disapprove a rule that does not fall within REINS scrutiny. So, and the reason for that is, 1, ultimate authority still rests with the legislature, and 2, I don't want to see an unintended consequence where the legislature gives complete deference to agencies and commissions with respect to rules that don't quite rise to the level of substantial economic impact. But why it's important, I think, for REINS to apply only to rules of substantial economic impact is that REINS is a good governance proposal. It's striking a balance between agencies being able to carry out the will of the legislature efficaciously, effectively, but preventing them from overstepping their bounds or from the legislature giving up a little bit too much authority and allowing them to pass rules that may have deleterious effect. If REINS were to require legislative approval in small matters, it would naturally, unnecessarily hamstring the General Assembly and bring state government possibly to a halt. With REINS, the General Assembly would not be bound by actions of previous legislatures that have given up too much authority to agencies. So consider a law that was passed 10 years ago that may have given too much sway to an environmental agency, for example. With REINS, the General Assembly can keep their eye on what's going on there. So as I see it, what a well-crafted REINS Act would do is it would increase accountability for and transparency in the regulatory process. It would return improperly delegated legislative authority as opposed to properly to carry out the will of the legislature. It would bring about more carefully crafted rules because I believe that agencies would want to withstand legislative scrutiny. And it would bring about more carefully crafted laws because the legislature would not want to create confusion among the agencies as to exactly what they intend. So my optimistic view is the expected outcome would be a slower, more deliberate, and less aggressive regulatory environment. And I see that as very important because the bulk of the academic literature means that would encourage a greater rate of economic growth in the state. Two things that REINS is not, and I think this is also important to explain. It's not the same as the 1996 Congressional Review Act. That act is very similar, it seems like, in that it gave Congress a mechanism to act to overturn agency rules. The difference here is, under CRA, the General Assembly would have to voluntarily take it upon themselves, upon their own initiative, to act to overturn a rule. If they did not do that, the rule would proceed. This, as I spoke of earlier, pits the deliberative process of the legislature against itself, so that even if the rule seems controversial, unjustifiable, excessive, there's just not as much time in the session possibly to bring up legislation to block it. And the other thing REINS is not, it's not a way to cut red tape. REINS is a way of slowing the growth of deeply impactful rules. It's a good governance reform. It's a reform of putting the legislature more in charge of their own rulemaking authority with respect to deeply impactful rules on the state. I believe it would promote more carefully considered legislation and regulation, but it is not a way to cut red tape. So when we look at this graph and the fait accompli of new regulations versus new bills, I would propose other sunrise reforms. Chief among those, in terms of cutting red tape, would be a Red Tape Reduction Act. Basically, trading in old rules before an agency is allowed to create new rules. Small business flexibility analysis, I think, is important because compliance costs are so impactful on small businesses as opposed to businesses that can afford compliant staff and that have more time to spend. Most states have, and the federal government, have a way to allow for small businesses to deal with regulatory requirements. North Carolina is one of 6 that do not. I liked the cost-benefit analysis that was added, I believe it was in 2011. I would like to make that reform stronger and make it actionable, meaning if it is found that a proposed regulation's costs exceed its benefits, then it should just go ahead and end and be rejected. I believe it's the position of legislature, not of an agency, to impose upon the citizens of the state, since they are directly accountable to those citizens, anything that would have a potential cost greater than benefits, economic cost. Full consideration of alternatives to regulation. By full consideration, I mean not just 2 other steps that we could take, but also keeping in mind that a potential is to not do anything. So when you're quantifying alternatives to and calculating alternatives to regulation, also consider making no change at all. I liked the no more stringency laws for environmental regulation. I would like to see that extended to other agencies. Stated outcome and stated objectives and outcome measures, I think, is very important, because there's always, no matter what you do, there's always a potential for unintended costs and unintended benefits. So in periodic review of a rule, see if it actually does what it was passed to do. And if it does not, then it should be rejected. If it has some unintended benefits for a single organization or group or industry, but it may be deleterious for the rest of the state, you've created a position for, you've kind of created a perverse incentive where you will be lobbied by the benefiting group to keep something that is maybe not beneficial for the rest of the state. So I think having stated objectives and outcome measures are very important. And one last one, which is not a sunrise, but I think is also important, is default mens rea provision. We have lost in this nation over the last few decades the old common law protection of mens rea, which basically means you actually have to be intending to break the law as part of breaking the law. With regulations especially, we've got over 20,000 regulations in this state. I dare say there's not a single person that could list them all and name them all. You can easily run afoul. A businessman, especially small businessmen, can easily run afoul of a regulation without intending to break the law, just not knowing the law. But without mens rea in the regulation or in the statute, they're under what's called strict liability, which means it doesn't matter. They're guilty. With a default mens rea protection, silence in the statute, silence in the regulation over mens rea would be taken to mean that mens rea is present, not that it's absent. If the legislature, if the regulatory agency wishes there to be a strict liability environment with that particular issue, they should make that directly and explicitly so it's not in there indirectly. So again, to review the features of REINS and the goals: affecting only proposed new major rules, requiring a joint resolution to affirm by the General Assembly within a set time period or the rule doesn't take effect, does not require the General Assembly to act so that the rule needs to be compelling on its merits, and prevents a major rule from taking effect without this resolution. If anyone has any questions, I'd be willing to take them.
Thank you, Dr. Sanders.
I can't claim a higher advantage.
I understand, but that leads into my next comment, which is, don't forget, we're just legislators. When you throw deleterious and efficacious and disambiguity at us, there are probably going to be some questions.
I will say, after I submitted this, disambiguity may not actually be a word. I think it's disambiguation. I couldn't find anything but that says that you can say disambiguity, but it sounded good when I wrote it. But my apologies if it's not actually a word.
Thank you. We appreciate your integrity on that. Are there any questions by the members? Yes, sir. Senator Daniel.
This might be more of a comment than a question. It looks like to me, Dr. Sanders, like the data that you're citing is really dated. I guess it's 6-7 years old, so I'm not sure it really gives us a current picture of where we are since the 2011 changes have been made. Is it possible that we could have more current data? Because now we've got the rule expiration process, so we know there's regulations that are, I presume, dropping off, and then there's new regulations that are being added. Is there somebody who's tracking that data as to, are there dips in the curve, or where are we? I think it would be helpful for the committee before we make any, statutory changes, that we kind of know what's the current landscape of our regulations and how have the changes that we've implemented been working or not working.
And that's a very fair point. The data that I had was from my predecessor at Locke, who looked at the regulations. I added the bill passages, and I had to do for the same time for it to be, statistically relevant. But no, the environment has changed, so I don't know how it compares. I would say that with a passage rate of 99.9%, it's probably still pretty doggone high. I don't know if that word is in the dictionary either. But yeah, that I think would be an important thing to look at, how the situation is more currently. But I haven't compared.
Follow up? Yes, sir.
So I don't know, Mr. Chairman, is there somebody on staff that can put that together, or should we ask the Locke Foundation to get us the information?
Right. Our first thought is Ms. Massich from the Rules Review Commission, Office of Administrative Hearings, is going to be talking about the periodic review, and maybe that will get at what you're asking. We could maybe revisit that in just a few minutes after the next presentation. Okay. Senator Robinson.
Thank you, Mr. Chair. Just, can you give me an example of, you mentioned 21,000 rules and $3.1 billion, and I'm sure you looked at all of those. Can you give me an example or a couple examples of some of those rules that cost like over $1 million or that you're proposing?
I heard over here a certificate of need, and that's certainly one of them. We spoke last week about occupational licensing. Those include fees. They include chasing education, paying for exams, maybe even a certain amount of time spent working in the field. The figures come from the Beacon Hill report, which I think is in there. So.
Follow up.
No, I'll read this. I'm just seeing this for the first time.
Right.
So I want a clear picture of those that cost over a certain. I'm not sure $1 million is the right kind of ceiling, but I'll read the materials and ask questions later.
Senator Wells.
Thank you, Mr. Chair. For Mr. Sanders, you mentioned in your remarks the issue of one group coming to the General Assembly and asking for regulation, licensing, whatever, protection that would effectively transfer money from the general public to that group. Say, one small group gets regulations or licensing in effect that moves $10 million into their account from the public, the general consumers. Is this a zero-sum kind of thing? That is, did we just did we move $10 million from one group to another, and that's the only effect, which means there's no overall effect to the economy? Or did, by us doing that, do we throw sand in the economic gears to the extent that there's a multiplier and it actually drags down the overall economy?
In my opinion, as an economist, when people are left to invest and make purchases with their own money, so that, for example, you want to support, you go to the local auto parts store or the local restaurant and invest there. The reason you're doing it, that's important to you. And the more people who are doing that, that is growing that particular area. When a legislative body transfers by statute or directly by taxation and moves investment elsewhere, there's a deadweight loss in time, and in my opinion, also in what's more valuable to the economy. So you have different people making valuation choices versus a single body deliberating over a choice. And so in my opinion, there's more loss to the economy with the transfer. So it's not a zero sum. I don't know if that answered it clear enough.
Further questions, comments from the committee? Yes, sir. Representative Floyd?
I know we're going into 6, which would answer some of the concerns that I have here. But at some point in time, we as legislators just can't, micromanage, our agency authority because, we're only meeting 6 and 3 months out of a calendar year. And so we try to exercise or give some of that authority, or not necessarily authority, but to allow agency to develop policies and procedures with statutes in which we implement. And then 6, as we go into the presentation, will sort of help us as they review some of these 21,000 rules. But I don't see how in the world that unless we increase the staff, that they can go through and evaluate these 21,000 within a reasonable period of time. So I think that as we go into 6, I think that may, really help to move us forward, as the legislators, because that particular agency or organization, reviews the statutes, and that's know whether or not.
No, I'm pretty much in agreement with that concern, which is why I think it's important that it only focuses on the most impactful rules. Otherwise, I agree with you. I mean, it would grind everything to a halt, I think, if a REINS Act applied to most rules. So I think only in terms of rules that would have a major impact on the state, however it's defined. The reason I mentioned for Senator Robinson, the reason I mentioned the 1 million is that's already in the statutes. So North Carolina has that statutory distinction. And in fact, that was changed. I think actually in my notes somewhere, I still have the previous listed as $500,000, and it's been changed since then. So what I'm saying is that, it's a distinction I think is important.
Follow up, Mr. Chairman?
Yes, sir.
Just I know it's in the statute of $1 million, but from your particular perspective, isn't that sort of low given the way dollars are moved through our economy?
I think it's about right, just because any less than that, I think would be, it would like $500,000, I think is a little not enough. But I think once you get to the million threshold, when you're talking about something that may affect, a few industries, I think that could be of major impact.
Further questions, comments? I had one question here, Mr. Sanders. Taking a look at your chart early on, cumulative cost of federal rules 1949 to 2011. That's such an eye-opening number, the opportunity cost that you have here. But I do have a question to play devil's advocate. The 53.9 trillion number, it says it in the acronym itself. GDP is a gross number. To think of what some of the critics might argue, does that not include safety and other things that would have improved our situation since 1949 and pollution and so forth? They would not be factored against that 53.9 gross figure, would they?
Yeah, and that's a fair question. And in my study, I make explicit with respect to the Beacon Hill and the numbers for North Carolina. Those are just cost figures. They are not benefits. So this isn't a cost-benefit analysis. This is an estimate of costs. So the argument could be made that yes, we've cost GDP, X amount of trillions, but the benefits that outweigh it, or the benefits that counterbalance it, are another number, and that's not estimated here. So it's very fair and proper to also mention benefits when you're discussing costs. So I want, it is in my study. It's not in the presentation because I knew it was already going to take a long time to mention that the numbers from Beacon Hill are just an estimate of cost. It's not an estimate also of benefits.
Thank you. I just thought that might need to be pointed out a little bit. Any further comments or questions?
Mr. Chair,
Yes, Representative Floyd.
may I speak to Mr. Sanders
Certainly.
before he exits?
Certainly. Okay.
Oh, you mean, okay.
All right. Thank you very much, Becki Gray and Jon Sanders from the Locke Foundation about the REINS Act. We appreciate your presentation.